For this video, we are going to discuss Article 159 of the Revised Penal Code, which is the crime of other cases of evasion of service of sentence. But actually, this pertains to the penalty to be imposed on a convict for violating the conditions imposed in his conditional pardon. Article 159. The penalty of prison correctional in its minimum period shall be imposed upon the convict who, having been granted conditional pardon by the Chief Executive, shall violate any of the conditions of such pardon. However, if the penalty remitted by the granting of such pardon be higher than 6 years, the convict shall then suffer the unexpired portion of his original sentence. These are the elements of Article 159. First element, that the offender is a convict. Second element, that he was granted a conditional pardon by the President. And third element, he violated any of the conditions of the conditional pardon. Now, with respect to the penalty imposable for purposes of Article 159, if the penalty remitted or cancelled by the granting of such pardon does not exceed 6 years, the penalty of prison correctional minimum shall be imposed. Whereas, if the penalty remitted or cancelled is higher than 6 years, the convict will have to serve the unexpired portion of his sentence. Let's go back to the first element, that the offender is a convict. Even if the article does not expressly state that the convict being referred to here should be one whose conviction has already become final, for purposes of the exercise of the pardoning power of the President, take note that a pardon can only be given after final judgment or after the conviction has become final. Now, with respect to the second element, that he was granted a conditional pardon by the President, the first question to ask is, what is the nature and effect of a conditional pardon? Answer, it is an onerous contract between the President and the convict to the effect that the former will release the prisoner subject to the condition that if he does not comply with the terms of the pardon, he will be subject to the provisions of Article 159. Another question, if the convict violates the conditions of his conditional pardon, is there still a need to charge him in court for violation of Article 159 before the penalties in the said article can be imposed? As a general rule, the answer is yes. He must still be charged, tried, and convicted because Article 159 is a distinct and separate offense. The President, however, under Section 64I of the Revised Administrative Code, may, in his discretion, order the arrest and incarceration without trial of a convict granted pardon or parole who, in his judgment, shall fail to comply with the conditions of his pardon or parole. Thus, the President may order that the convict serve the unexpired portion of the sentence, even if the penalty remitted or cancelled by the pardon does not exceed 6 years. Third element, that he violated any of the conditions of the conditional pardon. Now, if the convict granted conditional pardon commits a crime, whether under the Revised Penal Code or under a special law or even under an ordinance, like for example a traffic violation which is still considered penal in nature, he is deemed to have violated the condition of his pardon. But such convict must first be charged, tried, and convicted of the said offense before he can be prosecuted under Article 159. The exception is the President, like what I said in the previous slide, may in his discretion order the arrest of the said convict and recommit him to prison to serve the unexpired portion even without prosecuting him first under Article 159. Take note also that the duration of the conditions imposed under the pardon is only up to the last day of the remaining period of the sentence. For example, in 2001, X was sentenced to a penalty of 8 years for the crime of robbery. He had already served 6 years when he was granted conditional pardon in 2007. In 2013, he was found guilty of another crime, attempted homicide. Question: did X violate the condition of his pardon? The answer is no, he did not. Why? Because the duration of the conditions of his pardon is limited only to the remaining period of his sentence, which in this case is 2 years, or up to the year 2009 only. In such a case, he will not be deemed to have violated Article 159 of the Revised Penal Code. Now, let's go to the application of the penalty imposable under Article 159. If the penalty remitted or cancelled by the granting of such pardon does not exceed 6 years, then the penalty to be imposed is prison correctional minimum. For example, X was sentenced to a penalty of 8 years for robbery. He had already served 3 years. Thereafter, he was granted conditional pardon. Here, the term remitted or cancelled by the pardon is 5 years. Now, if he violates any of the conditions of his pardon, he will be charged under Article 159, and if convicted, he will suffer the penalty of prison correctional minimum. Take note again that this is without prejudice to the President's prerogative under Section 64I of the said code. I am talking about the prerogative of the President to order the arrest of the convict even without trial. Second penalty imposable under Article 159. That is, if the penalty remitted or cancelled is higher than 6 years, the convict will have to serve the unexpired portion of his sentence. For example, X was sentenced to a penalty of 8 years for robbery. He had already served 1 year. Thereafter, he was granted conditional pardon. Here, the term remitted or cancelled by the pardon is 7 years. If he violates any of the conditions of his pardon, then he will be charged under Article 159, and if convicted, he will have to serve the unexpired or remaining portion of his sentence, which is 7 years. Again, take note that this is still without prejudice to the President's prerogative under the said section of the Revised Administrative Code.